All right, we're jumping right into an incredibly fascinating explainer today. We're unpacking a topic that honestly might look super niche right on the surface, but actually carries massive, wide ranging implications for the entire future of tech and business. We are looking at the Supreme Court's newly released draft AI guidelines. Now, I know what you're thinking. If you don't work in a courtroom, you might be tempted to just totally tune this out. But stick with me here, because as we're about to see, the rules being written for the highest court in the land are going to send a huge ripple effect straight into the private sector.
So let's just pose the big elephant in the room question right up front. Why on earth should the private sector care about courtroom AI? I mean, if you're a tech developer, a corporate leader, or an AI innovator, why does a document aimed at judges in the judiciary matter to your bottom line? Well, that is the central mystery we're solving today. And the answer fundamentally shifts how we all need to look at AI compliance from here on out. Okay, let's dive into this. There's a really common misconception floating around. At first glance, most folks just read the headline and assume, oh, these proposed AI usage guidelines apply exclusively to the judicial sector. But Navy's analysis offers a much broader and, frankly, a much more vital perspective here. They point out that these guidelines are actually highly applicable to the private sector and the entire tech industry. And we're going to break down exactly why that is.
Here's our roadmap for the explainer. We'll quickly cover 1. The Supreme Court's AI rules, 2. The hidden industry ripple effect, 3. Setting the due diligence standard, 4. Impact on software vendors, 5. A deep dive into key AI topics, and finally, 6. The ticking consultation clock.
Starting with Section 1, the Supreme Court's AI rules, specifically the guidelines for the judiciary. So the core event that kicked all of this off is pretty straightforward. The highest court of the land officially released a comprehensive document. It outlines proposed guidelines for how artificial intelligence can and cannot be used within the judiciary itself. And they've opened this up for public comments. Now keep in mind, this isn't just some casual inter-office memo. This is the Supreme Court actively establishing a formal structural framework for AI governance within its own walls.
Moving on to Section 2, the hidden industry ripple effect, moving beyond the courtroom.
And that leads us straight into Section 3, setting the due diligence standard, creating a benchmark for all. Now, this quote right here brilliantly illustrates the absolute core of Navi's argument. This document is therefore a due diligence for the rest of the industry. Think about the logic for a second. This document is issued under the support of the highest court of the land, right? It reflects the fundamental thoughts of the judiciary on how AI should be safely, ethically allowed to operate. What is recommended and strictly enforced for the judicial sector will inevitably become the benchmark. It trickles down. Even if it's to a slightly smaller extent, these exact standards are going to be expected in the private sector too. Basically, if the highest court says, hey, this is the safe way to use AI, private enterprises are going to be judged against that very same standard in the court of law and, honestly, the court of public opinion. Let's look at Section 4, impact on software vendors, specifically those selling to the judiciary. All right, this moves us from legal theories straight into immediate, on-the-ground commercial reality. The private sector has a massive, direct stake here simply because they are the ones actually building and selling software to the judicial sector. This software generally falls into two main buckets. First, you got AI built for administrative requirements, scheduling, filing, basic organization. But second, and far more critical, is AI intended for use by a judge in arriving at their actual decision. These new guidelines create hard, undeniable definitions of what kind of AI usage is permitted and what is absolutely not. So if you're a tech developer, your product literally has to align with these new definitions, or you simply cannot sell to the courts. It's a total game changer. Section 5, deep dive into key AI topics. Doing a real deep dive into the guidelines themselves. To help everyone digest this massively complex document, Navi actually published a series of 11 analytical articles over just a few days, covering a staggering volume of deep topics. On June 11th, they looked at how these rules preempt broader AI regulations in India. Then, moving along to the 14th, we see incredibly specific analyses on how frameworks like DGPSI, AI, are reflected in the draft, and the direct impact of SCAF on AI developers. And looking at June 13th, the analysis expanded into strict data protection obligations, oversight, developing competencies, and the general principles of AI governance. I mean, this is effectively an entire curriculum for understanding the future of AI compliance. And honestly, recognizing that this is a super dense, highly technical subject, there is a fascinating meta layer to how this information is being shared. Navi actually utilized an AI assistant to create detailed audio and video reviews of all these articles. It's just a brilliant, highly practical way to make these incredibly complex concepts much more accessible, letting you digest all this material super efficiently. Finally, Section 6, the ticking consultation clock, because time is truly running out. So the crucial point really comes down to this number, 20. The source material emphasizes over and over that there is very little time available for public comments on a framework of this magnitude. The strict deadline to submit your feedback is June 20th, 2026. Now, while that year might sound a bit distant right now, the sheer scale of adapting your tech to these due diligence standards means the tech industry and the private sector really have to begin forming their strategies and responses right this second. Because of that tight window, you've got to take action immediately. Here is the exact, clear path forward outlined by the source. Step 1, you need to read the analysis materials and form your own independent views on how these rules are going to impact your operations. Step 2, draft your specific concerns, your objections, or any suggestions regarding the guidelines. Step 3, you must email those comments directly to the member secretary at office.reg@csi.nic.in before that June 20th deadline. If you've got concerns, this is your officially sanctioned avenue to actually express them. Which leaves us with this final, absolutely vital question to chew on. Will your AI meet the Supreme Court's standard before the clock runs out? Because whether you are directly supplying the courts or you're simply operating in a private sector that is about to adopt these new definitions of due diligence, the bar for AI compliance has just been raised by the absolute highest legal authority. I highly recommend diving into the source materials, utilizing those AI-generated audio and video reviews, and making sure your voice is heard in this critical public consultation. Thanks so much for joining me for this explainer.